appearing in the appeal of German Management against Firefox Ltd and 21 others.
Yes, Mr. Conway.
May it please your lordships, I appear for the appellant, GEM. My learned friend, Mr. Duval, senior counsel, appears for the respondents. This appeal turns on the application of essential principles of contractual interpretation to a short agreement drafted by the respondents. The agreement entitled GEM will receive a fee known as a commitment consideration on the sale by the respondents of their shareholding to anyone other than GEM during a defined period known as the commitment period. As your lordships will have seen, the agreement contained a number of provisions ancillary to that on which GEM relies. I propose first to set out the relevant principles which are embodied in the Civil Code of Mauritius and are not in dispute. Secondly, to take your lordships through the terms of the agreement. Thirdly, to show your lordships the respects in which the Court of Civil Appeal's analysis was, with respect, wrong. And I should say the Court of Civil Appeal, as your lordships will have seen, essentially adopted the analysis of Sir Justice Ango at first instance. Unless it would particularly assist your lordships for me to go separately through the first instance judgment, I don't propose to do so. Fourthly, to set out what is, in my submission, the correct approach. I shall give references to the key documents bundle if that would assist, but if all of your lordships are working electronically, perhaps it would be simple.
Electronic page numbers will be of great assistance.
I'll give both, unless it wouldn't be helpful for me to give the key docs.
I think you can probably just use, unless any of my colleagues think otherwise, just use the electronic page numbers.
I'm grateful for the indication, my lord. Turning first to the relevant principles, these are laid down in the Mauritian Civil Code. They are produced in the authorities volume of the electronic bundle at page 301, but are set out together with translations in GEM's written case at page 283. My learned friend has kindly indicated that these translations are agreed. That was at page 283 in GEM's written case. Perhaps easier to take them there with the agreed translations next to them. Paragraph 15.1. The starting point is Article 1156. One must ascertain the contracting party's common intention rather than merely the literal meaning of the terms. And my learned friend, I think, makes the point that in the case of a unilateral contract, that's in the strict civil law sense, where only one party has obligations, there's not quite the same question of determining the party's common intention, but I don't believe it to be controversial that the rule still holds that one must not stop at the literal meaning of the terms and must still endeavour to identify that intention. Article 1157, when a clause can bear two meanings, we would say, or more than two meanings, it must be understood as having that which gives it some effect, rather than that which produces none. Article 61, each clause in a contract must be interpreted in light of the others, giving each the meaning which arises from the instrument as a whole. And Article 1162, in case of doubt, contract is interpreted against the party who has stipulated and in favour of the party who contracted the obligation. I'll come back to Article 1162, which raises separate considerations. As to Article 1157 in particular, I would draw your lordship's attention to the case of Bohemia, which is at page 304 of the electronic bundle. That was a case in which Mr. Justice Mungley Gulbel, sitting in the commercial court, was called on to interpret an agreement not dissimilar to the agreement before the board, in that it entitled the plaintiff to a percentage of the value of a construction contract awarded to the defendant. The case is, however, instructive less for its analysis of that contract, which turned on its particular provisions, but rather for the judge's citation at page 309 with evident approval of the academic commentary on those articles, and in particular, Article 1157. In the second paragraph of the page, Mr. Justice Mangli-Gulbul begins by setting out what I said a moment ago about literal interpretation, and then cites, in the second half of the page, a passage from Traité pratique droit civil français, and there's a note there, number 451, in the particular passage, which provides some analysis of 1157 rather than, in the case of some of the other articles, merely recapitulating it. Explains that if there are two meanings that are equally viable, you must choose the one which is susceptible of producing some effect, rather than one which produces none. We've seen that. That's the text of Article 1157. And then he mentions also that this rule can be traced all the way back to Ulpian's Digest, from which is drawn the well-known adage of which we would shorten to melior ut valeat quam ut periat. As a rule of thumb, moreover, in my submission, one might well say that the shorter the agreement, the more important that rule is going to be. Applying those principles, or rather having those principles in mind and turning to the text of the agreement, that is at page 113 of the electronic bundle. It is, as I say, a short agreement with the substantive provisions finishing on page.
Before you come to the agreement,
yes,
or at some point, can you explain what the procedural rule is that we're operating under? I'm assuming it's something equivalent to a demurrer, where the facts pleaded are assumed to be true.
Yes, that's exactly right.
Is there some statement of that, of what
yes,
the relevant procedural
precisely that point is
means, or what it is, what the process is?
Is it a preliminary issue,
yes,
or is it an application to strike out on the basis that it's frivolous, vexatious, or an abusive process of the court? Which of the two is it?
Closer to the latter. It's not a preliminary issue in the sense of being a trial on preliminary issues. It is a plea, what indeed in the Scottish courts one would think of as a plea to the relevancy, if your lordships are familiar with that, and sitting in Scottish appeals, as I understand it. One takes all of the plaints, all of the facts as averred in the plaint with summons as true, and asks whether on the basis that those facts are assumed to be true, the plea taken by the defendant to the potential well-foundedness of the case succeeds. So it is on the defendant's preliminary plea, a plea in limine, to the plaintiff with summons. And much as we would have, as my Lord Stevens identified in a strikeout in English law in Northern Ireland, a strikeout simply conducted on the basis of the correctness or not of the contractual position, here we're doing much the same. The relevance of the procedural position for the purposes of the substantive arguments really comes down to the fact, as I've highlighted in the written case, that the court below, both courts below, really failed to accept as true the fact that the agreement was actually authored by the defendants or the respondents, and therefore misapplied Article 1162.
Is there any other relevant fact?
We say what is in fact obvious or appears on the face of the agreement is also relevant by way of background, that the agreement, as I was about to show your lordships, is expressed to be for the benefit of GEM, its unilateral undertaking, and that the context of it was that GEM was in parallel with the conclusion of the agreement making a proposal in an agreed form, or at least in an envisaged form, to acquire up to 100% of the shareholding of the underlying company, Deep River. But otherwise, no, the factual context really boils down to that, and the appeal is concerned much more with the internal logic of the contract. I should say as well that if the appeal succeeds, then the plea in limine litis fails, and the case would then go forward to a hearing on the merits at which, for example, the question of the authorship of the undertaking agreement would be determined on the facts following examination of witnesses and documents. And indeed, the common intention of the parties might also raise factual issues as under Mauritian civil law.
The common intention is to be derived from the contract, and not from evidences about what was said or done prior to the contract.
For the purposes of this preliminary plea, that's certainly my position. I simply don't want to foreclose the matter should indeed the appeal succeed, and then it to be considered in more detail at first instance in Mauritius thereafter. Contract, as I say, is at page 113 of the electronic bundle. The first point is one I mentioned just a moment ago. Just below "Dear Sirs," it's an irrevocable and unconditional undertaking agreement in favour of GEM Management Ltd. It is intended to operate in GEM's favour expressly and not to be in any way a balance of obligations. Then there's the paragraph "We Deep River," but beneath that, "concurrently herewith." GEM Management is going to make the proposal, or is making the proposal. That's important because it is not something that GEM is doing hereunder or pursuant to this contract. It is happening in the background. It is the context of this proposal. It is not an obligation of GEM's to do this. Thirdly, we see the next paragraph, "in consideration of the substantial direct and indirect benefits to the shareholders." That, again, I think is uncontroversial, is not consideration in the sense that, as English lawyers, one might understand it. It's rather in a looser, non-technical sense. It's having that in mind. And in the second half of that paragraph, the respondents confirm their irrevocable commitment for the duration of the commitment, that commitment being to pay the commitment consideration. The second half of that paragraph introduces the phrase "commitment period," doesn't define it, but the definition is in effect supplied by the next paragraph. "The commitment period shall initially endure until the 31st of December 2012, and GEM has a right but not an obligation further to extend the commitment period until the 31st of December 2013, and if so, it shall communicate its election in writing to the shareholders, who are the respondents." It is significant in my submission that that is the only right, the only primary right that GEM has under the contract. That's to say, it's the only primary right it can exercise under the contract. It has a passive right to receive the commitment consideration as and when it's due, but that follows automatically from the respondent's obligation to pay it if the conditions are met, as we say they are. But there's nothing else that GEM has to do or can do in terms of its primary obligations other than communicate its election to extend the commitment period.
Well, it's not an obligation, is it?
No, it's not an obligation, it's a right. But that's my point. It's the only right that GEM has, other than its passive right. It's the only right it can exercise. The only notice it can serve is this one. What is also crucial is that this paragraph is a definition of the duration of the commitment period. It is not, and does not bear to be, a definition of the duration of the agreement as a whole.
What's the purpose of the communication in writing?
Simply to communicate that GEM has exercised its right to the respondents.
Give them notice, presumably, that if they now were to sell the shares, it would be subject to the commitment.
Yes, on our case, they are effectively on notice of the possibility of that from the outset.
No, but they're not on notice of the election, are they, until they've received a notice?
No, we accept that that's true. It is.
So it's a pretty strong indication, isn't it, that it's intended that you get the notice before the obligation arises.
It points in that direction, but in my submission, it is outweighed by the fact that once one follows through the logic of that position, which was adopted by the Court of Civil Appeal and is adopted by the respondents, one cannot then give effect to the waivers on which GEM relies. Those would be deprived really of any sensible effect at all. And the price one pays, and that is a much more serious price in my submission than the point identified by your lordship, by my Lord Legate, that the notice would be, as it were, only contingent until and unless GEM exercised its right. But certainly there can't be any serious doubt in reality on the respondent's part that the notice is going to be served at some point. It is an odd provision.
Would you say there's any time limit at all on when the notice could be served?
Yes.
Must it be served by 31st December 2013, or could it be served now if they hadn't got round to it by then?
No, it must be served by 31st December 2013. We don't in any way say this.
Well, where do you get that in the words of the clause?
We don't get it from the words of those clauses. We get it from the definition of termination agreement, which we say resolves to 31st of December 2013. Okay. And I'll take the board through the logic of that. But to return briefly to my Lord Legate's point, on either party's case, and I stress on either party's case, the mechanism of the extension notice is an odd one. It is a right that one cannot imagine GEM not wanting to exercise.
Well, all they have to do is the day after the undertaking's made, they exercise the right.
Yes.
Well, they some whatever reason, they didn't.
For whatever reason, they didn't. But one can't imagine a situation in which they wouldn't want to. And as I stressed, that's a quirk on both parties' case. It's not unique to GEM's case. This being a plea in limine litis, there hasn't been any evidence before the board, as there might be before the commercial court at first instance, if the case proceeded to a hearing on the merits of what the intention was, which would be admissible in Mauritius. The intention being a question of fact, treated differently from...
The way this is structured makes one think there must have been a reason why GEM didn't simply go for a 2-year period. But we just shouldn't speculate, should we, as to what that reason was? It's not in evidence. No,
I'm not inviting the board to speculate. Indeed, we rely on the fact, of course, that the respondents were the authors of the undertaking. If it doesn't go into impermissible speculation, we might well suppose that the mechanism was simply vestigial from a precedent in which there was a true exchange of value, ill-adapted to a situation like the present, which, on the face of the contract, operates solely in favour of GEM. And when one looks at the logic of the contract, it's difficult, as I say, to imagine GEM not wanting to exercise.
GEM have to do two things, don't they? They have to, first of all, elect, and secondly, give notice if they're going to satisfy the purpose of the election.
Yes.
And they didn't, because the letter of the 12th of November 2013 on the second page states that they believe they didn't require to recommit. And so it's only then that they elect, and it's only then that they serve notice.
Yes, Jem's case is certainly not that silently, unbeknownst to anyone, they had exercised the right, but before communicating it, we accept that the notice was served at the point at which the election was made. Yeah. It is true that there is the, one might call, protective wording about not being required to recommit. That is not something on which any issue in the appeal turns on my submission. I'm not entirely sure what one draws from that, but procedurally, I dare say Mr. Duval will point out the election notice wasn't before the first instance court or the Court of Civil Appeal. We have no objection on our part to looking at it, but I would just draw the board's attention to the fact that, as one may have seen from the transcript of the first instance proceedings, is rather a formal process that has to be gone through in order to admit a document into evidence for the purposes of a plea in limine litis. Also reminiscent of the Scottish procedure, at least as traditionally operated. Then over the page, we have the definition of the termination date. At the very top, for the purposes of this agreement, and depending on Jem's right to further extend the commitment period, 31st December 2013 shall hereinafter be referred to as the termination date.
Does that mean that if they didn't extend, that the termination date is the 31st December 2012?
We say no. And I accept that the meaning of that clause, the words depending on in particular, don't immediately yield their purpose. But once one goes through the exercise of looking at the remaining provisions of the contract, seeing what they must mean, and then in light of those as required by the Mauritian Civil Code, coming back to the definition and effect of the termination date, really it resolves to it resolves to a provision that the termination date shall be 31st December 2013.
What do you say the termination date is, in the sense of, is it, obviously it's the end of the commitment period, and that is the period, is it during which the right can be exercised, or the period during which, no, the period during which, if there's a sale, the money is payable, is it?
Yes, unhelpfully, the definitions are often separated from the provision that gives effect to them. The termination date is, in fact, defined in the bottom of page 125, the first sentence of the, it's not defined, rather it's given effect.
Right.
At the last paragraph and the bottom of page 125.
You mean electronic?
Oh, I'm so sorry, 115. Great from the Lord.
So what bit are you pointing to on 115?
115, very last paragraph.
Yes.
First sentence. This agreement is a continuing agreement and shall remain in full force and effect until the earlier of payment of the commitment consideration or the termination date.
Well, so if they don't pay up by the 31st of December 2013, they don't have to pay at all?
Well, certainly we say...
You're not arguing that point?
No, we're certainly not arguing that point. And in fact, as I'll develop later, it's a virtue of our position that we don't have to give too rigid or doctrinaire a meaning to the termination date. Really, on the Court of Civil Appeals approach and the Respondents' approach by extension, the shutters come down at the end of the commitment period, and that includes on not just the waivers on which we rely directly, but on all of the ones that we point to as highlighting the logic of the contract, which, if one turns over the page, for example, one sees on page 116 that the agreement is governed by an express choice of Mauritian law. Obviously, that choice must continue to have effect beyond the termination date. Similarly, at the end of that paragraph, the respondents irrevocably and unconditionally waive to the fullest extent, etc., any objection they may now or hereafter have, effectively to forum non-convenience arguments. So we say it simply cannot be right all of the rights and obligations under the contract vanish at the end of the commitment period unless GEM has exercised its right to extend during the commitment period. My submission, that's obviously right of the provisions we've just looked at, and as I'll explain presently, it's also right of the provisions on which GEM has relied. Turning back to page 114. We were at the top paragraph with the definition of termination date. There are then three main operative paragraphs, as it were, about payment of the consideration. And then thereafter, from the paragraph about 40% of the way down, the liability of the shareholders under this agreement. From there on in, the remaining approximately 50% of this agreement, or two-thirds of this agreement, are waivers and other protective provisions operating solely in GEM's favour. And that is an important point in my submission when one comes to interpreting it. We don't rely directly on this block of waivers, the liability of the shareholders shall be irrevocable and so on. Again, we point to it as showing just how strong the protections for GEM were, and if I may say, and frankly, how improbable the circumstances GEM's right would be preserved. GEM's rights are preserved if the commitment is invalid, if there's a change in the existence of shareholders, if it is impossible for the contract to be performed, and then perhaps most strikingly at little e, one has to take that with the chapeau, as it were, but the shareholders irrevocably waive any defences in any way relating to, with e, any circumstances, event or happening whatsoever. It's difficult to imagine more broadly worded provisions. And then in that context, one comes to the next provision, which is one that, for want of any numbering or labelling, we have called the late notice waiver. That is one that says the shareholders hereby waive promptness, diligence, notice of acceptance, and any other notice with respect to the commitment. And concludes that we acknowledge this agreement is continuing in nature. Again,
why does it say all notices?
I'm sorry, did I say almost
it
any other
say
notice?
Any other notice.
Any other notice.
As opposed to all notices.
I think it's simply any other notice as opposed to notice of acceptance, but we say there is no notice of acceptance required in any event, especially given that over the page on little f we see that there are no conditions precedent to the effectiveness of the agreement. So if there is no notice of acceptance actually stipulated as required in the agreement, if there was one, the need to serve it would be waived by this provision, and in any event, even if we were one prima facie to construe it as a condition precedent, the provision on the following page would say that's not a condition precedent after all, and GEM still has its right to be paid.
Does that mean that GEM don't even have to elect and don't have to serve any notice at any time at all?
We certainly don't go that far. It's been accepted throughout that GEM has to at least serve the notice of the exercise of its right. It wouldn't do GEM terribly much good to exercise that right silently in a dark room without telling anyone to.
No, but what's to stop it exercising it in January 2014, for example? Where do you get in the agreement on your construction the cut-off point for the exercise of the right?
We say that follows the termination date. We say that the content that at least has to be given to the termination date is that it is the end date of GEM's primary rights. Or rather, by which it can exercise its right to extend, I should say, because it's still entitled to payment thereafter. That's the cut-off date for the exercise of the right. It's 31st December 2013. The result of that, coming back to my Lord Legate's question earlier, is that, yes, as the respondents have pointed out, that means that for at least a portion of 2013, the respondents may well be in some minor uncertainty as to whether the right is going to be exercised. But as I explained earlier, given the commercial context of the contract, its rationale, it's difficult to imagine that's not going to be exercised, and one sees that in the context.
Well, what's the point of having any option at all then on your approach as opposed to just simply a 2-year period?
Well,
I mean, you deprive that of any function at all, really, don't you?
We don't deprive it of function. It doesn't have a clear commercial rationale, I stress, on either party's case.
No.
That's why I say, without trying to speculate, may well be vestigial. The court hasn't heard evidence on that.
Well, then you could say, well, the waiver clauses are just boilerplate, it's vestigial, and we don't bother about those.
There is an important difference, not just of degree, but category in our approach with the respondents. What we say is that the waivers actually do have an effect, and indeed the extension mechanism has an effect and can be operated. It's just that the rationale for the extension mechanism is less clear. But on the respondents' approach, there's no rationale for the extension mechanism. It operates just as it does on Jem's case, but there is no effect at all really given to the waiver provisions on which Jem relies. And it's that lopping off ineffective parts of the contract that we say is the strong indicator that it's the respondents.
But I mean,
which is wrong.
You could make the point the other way. If the intention was to say it doesn't matter if you exercise the right after the 31st of 2012, that's what you'd expect it to say. But it doesn't say that. It just says any delay. But you might say, well, if you wait till the 29th of December 2013, it prevents any possible argument that you've left it to the last moment.
Yes, well, one could say that. The two answers are, first of all, in the content of the waivers on which we rely, and secondly, on the fact that under Article 1162 of the Civil Code, at least for the purposes of the plea in limine, if there is an uncertainty in the operation of the contract, that has to be resolved in Jem's favour. The point identified by my Lord Legate a moment ago might well fall into the category of a point that Article 1162, for the purposes of the plea in limine, would operate in Jem's favour.
If the commitment was triggered, and presumably the notice would need to be given of where payment should be made, wouldn't it?
At some stage, payment would have to be made. The destination of payment would have to be made, but
So wouldn't Jem give notice of where it wanted to be paid?
Eventually, but I don't. Our reading of the contract is that's not a requirement under the contract. It's not. Well, first of all, looking at the substantive provisions for commitment consideration, suppose there's no extension at all. The right to payment is automatic, and the modalities of that payment will then be a matter to be resolved between the parties, but not as a precondition for payment.
Right, but I was understanding your argument to be that we have to treat the waiver provision as applying to the election to extend the termination date because it really didn't have anything else to do. And what I'm putting to you is surely it does have something else to do, because notice will need, if the commitment falls due and is triggered,
yes,
notice will need to be given by Jem as to where it wants to be paid. And can't one give effect to the waiver provision by saying, well, if they've delayed for a year before they give that notice, that doesn't affect their rights to receive the money?
Yes, I see the point. The two answers to that would be, first, that that's not a notice that in my submission is actually envisaged as being required by the contract, even though commonsensically one might well expect it to be given. And the second is that the delayed exercise clause, as we've called it, is even broader than that. isn't restricted to notices, but is also restricted, would apply to the substantive exercise of the right to extend, and also has no purpose on the respondent's case.
Right.
So I've been looking at the late notice waiver, which on the respondent's case has at best very limited effect. But I'll come in a moment to the other waiver I mentioned.
Yes.
I'll do that now. It's on page.
Before leaving that point, under Mauritian law, is the obligation to pay the creditor at his place of residence or his place of business, or alternatively, can the creditor elect to be paid at a certain place?
My Lord, I'm afraid I don't know the answer to that question. I'm certainly happy to take instructions. I'm not sure I would necessarily get them.
My understanding of the law in the United Kingdom is that you pay the creditor before he carries on business, but he can elect and can serve notice that he wants to be paid somewhere else.
Yes.
And that would be a notice that would be required to be served by GEM.
Yes, that dovetails a little with my answer to my Lord Sale's question, which is, again, we say there's, bearing in mind, for example, the forum non-conveniens waivers and the sort of litigation-focused waivers, there's a distinction that ought sensibly to be drawn between what I've referred to as the primary rights and under the contract and the notices expressly envisaged by the contract, and notices that might arise reflecting rights, or notices in respect of rights arising ex lege, secondary rights, and so on, that would arise ancillary to the contract, but not necessarily envisaged within its machinery. But I take the point. One could serve that notice. It's just that, again, it's the same two answers as I gave to my Lord Sales. It's, first, that's not a notice we say under and for the purposes of the agreement as such, and secondly, if I may then come to page 115 and look at what we've called the delayed exercise clause, all the same points apply, except that it's even broader in GEM's favour.
And how about a notice inquiring as to whether the shares have been sold?
I mean, I see the point. It was also a question of interpretation, I suppose, whether that's strictly a notice or it's a notice in the sense envisaged by this. There's no such thing as strictly a notice or not strictly a notice, but is it a notice to which, on its true construction, this provision is referring in my submission? It wouldn't be. Over the page, however, we've got on page 115. I looked at the bottom paragraph earlier. This agreement is the continuing agreement, etc. Above that, we have the provision, no failure on the part of GEM to exercise, and no delay in exercising any right hereunder shall operate as a waiver thereof, etc.
Not suggested there is a waiver, is there just a lapsed right?
Well, quite. But the point, however, is that GEM's right is preserved, we would say, reading that in line with the waiver on the previous page. They sort of dovetail together in the context of the extension notice, just to say that the right is preserved by the late notice waiver, and therefore it hasn't lapsed for the purposes of the delayed exercise clause. And under the delayed exercise clause, they're still entitled to exercise it, and not only no delay, but no failure to exercise that right shall operate as a waiver thereof.
So that's all subject to the interpretation of what the period is within which the right must be exercised. So that's the controlling feature of the agreement.
Yes, and then we come back to the date, the definition of the termination date, or its effect. We say that does resolve to the 31st December 2013. Because, cutting it short, and I mean, this is more or less getting to the end of what I was going to say about that, because in our case, it must be right that this delayed exercise clause, the late notice waiver, operate past 31st of December 2012. Otherwise, they really, at least in relation to the extension notice, have no real function to perform. those must continue in force until at least 31st December 2013. And therefore, coming back to the top of page 114, for the purposes of this agreement, and depending on GEM's right further to extend the commitment period, 31st December 2013 shall hereinafter be referred to as the termination date. That we say resolves in short to saying that the termination date is effectively the 31st of December 2013. Depending on, one could give more weight to the words depending on, and one could say, well, bearing in mind that the waivers continue to operate, the termination date is somewhat held in abeyance until and unless one sees whether GEM exercises his right. That would be a tenable view. It's one that would still operate in GEM's favour. But we say really the more natural reading is simply in light of the contract as a whole and giving effect to each of its provisions as one must where possible. The more natural and simpler reading is that resolves to termination date is 31st December 2013.
What do you mean that resolves to? What does depending on mean?
Well, depending on those particular words on this approach would mean something like subject to or in light of. It's important on any view to say it's not depending on the exercise of GEM's right to extend. So we would say it's in light of GEM's right to extend, but not simply depending on whether it's exercised or not. One could read depending on as meaning depending on whether GEM's right to extend is exercised. One could read those words in, and GEM, in my submission, would still succeed if one did, because that is read subject to the waivers. But it does appear to be a less natural, less satisfactory reading of the contract to hold the termination date in abeyance during 2013 until and unless GEM happens to exercise its right. Rather, we would say simply it means in effect, given GEM's right to further extend the contract, it's 31st December 2013.
Can I ask you just to go back to page 114?
Yes.
And the clause that says the shareholders hereby waive. What's meant by the phrase, we furthermore waive any right to revoke this agreement? What rights were there to revoke this agreement?
None that GEM is aware of. Again, it's slightly straying beyond what we say is necessary to resolve the plea in limine, but certainly subject to any arguments GEM might make in future if the appeal succeeds. For these purposes, in my submission, there was no right to revoke the contract. It's a right, if any, to revoke the agreement and acknowledge that it's continuing in nature. It's effectively meaning that it is a binding and effective contract that will operate according to its terms until and unless the termination date provisions kick in, and always subject to the ongoing, as I say, litigation-focused waivers. So that's how we say the contract operates. If one then looks at how the Court of Appeal dealt with that, that is, I'm working from the key documents bundle, but the key passage is in electronic page 206, or rather 207, I should say. And the key, what we see there is simply essentially an adoption of the short reasoning of Mr. Justice Ango at first instance. Looking at that block paragraph, which becomes the reasoning of the court by virtue of its adoption, the block quotation, though the plaintiff has sent a letter And though the plaintiff has sent a letter, the second half of that sentence is important. It's obvious that this notice, and the notice was sent after the expiry of the first commitment period. We say so far so good. It was sent after the notice, after the expiry of the commitment period, and should not therefore be taken into consideration. We say that's wrong. It had to be taken into consideration for the reasons I've given and shall develop again presently. And then he goes on to explain the effect of Article 1162, that it should be interpreted against the party who has written it and in favour of the other party to the contract. We say that's the correct approach. It's not, as I think pointed out in our written case, it's not quite the meaning one gives to the contra proferentem rule in English law. It resolves to a more binary question of who has written the contract, and if they've written it, doubts are resolved against them. But coming back to the primary questions of interpretation, the Court of Civil Appeal says underneath that, we agree with the reasons given by the learned judge. The second sentence, with regard to the commitment period, the words shall initially endure until December 2012 indicates, in our view, that the parties intended the agreement to remain in force until 31st December 2012. And we say that is wrong. It is not expressly supported by reasoning as to why one should immediately identify the commitment period with the duration of the agreement itself. And I'll come back to, again, to why. But for present purposes, the point is that is an identification that's made, that's an equiparation that's made without supporting reasoning, and simply in the course of that sentence there, which is then carried through the rest of the judgment. And this was, however, subject to the appellant's sole discretion to extend the agreement, provided it sent a written notice. Over the page, at the top of page 208, there's a summary of submissions. At the end of that first paragraph, the court mentions the appellant's submission that the respondents had waived defences, including the need for promptness and formalities. It develops that over the page, so I won't dwell on it here. It then says, we find no merit in the appellant's contentions. The second sentence, the express inclusion of an extension mechanism in the agreement could only mean that the agreement would come to an end at the end of the initial commitment period. Again, that's simply the error from the previous page carried over without further discussion. It does not follow in my submission that the commitment period, the end of the commitment period was the end of the agreement, unless the appellant availed itself of its right to extend the agreement. Again, it wasn't a right to extend the agreement, it was a right to extend the commitment period. It may well follow from the Court of Civil Appeals analysis that would then be an extension of the agreement, but that is already straining the language of the contract, and that is already a signal that something has gone wrong. It's common sense, the Court of Civil Appeal says in the next paragraph, that the written notice for extension would have to be served during the lifetime of the agreement. Again, that's now rephrasing the point that had been made previously by reference to the commitment period. Before the expiry of the first commitment period, treating the two as the same, unless there was an express contractual provision to the contrary, or the parties had agreed otherwise, which was not the case. We say that there were express contractual provisions to the contrary, and I've taken your lordships to them. And then the conclusion, we find the appellant's failure to extend the commitment period prior to its expiry during the lifetime of the agreement meant that it had allowed the agreement to lapse and that it was no longer valid and enforceable. There's then, again, something of a summary of submissions. They come back to the point about the waivers on which GEM had relied. On page 209, they mention hereby waive promptness, diligence, notice of acceptance, and so on. They don't mention what we've called the delayed exercise clause. That was the no failure or delay in exercising a right. As set out in our written case, that was expressly relied on by GEM in the Court of Civil Appeal, both in writing and orally. And again, they find no merit in the appellant's submission. It stands to reason that any obligation of the respondents would subsist only for the duration of the commitment period. Wrong for the reasons I've given, but as stated above, it was no longer valid and enforceable when the appellant purported to give notice. And an interesting sentence, in fact, the appellant benefited from an extension clause which he failed to exercise in a timely manner. And of course, those words, failed to exercise, in our submission recall precisely the wording of the clause to which the court's attention was drawn, but on which it didn't rely, that no failure to exercise the right would amount to a waiver of it, thus allowing the agreement to lapse. I would also just mention that the misprint there, the appellant, which he failed to exercise, the appellant is a company incorporated in the British Virgin Islands. Lastly, in the Court of Civil Appeals analysis on page 210, there's the treatment of Article 1162. I'll explain in a little more detail, which is in my respectful submission, a misunderstanding of the position. The appellant also complained that it should have been allowed to adduce evidence to clear any ambiguity as to the authorship of the agreement. We do not agree. The real issue was the interpretation of the extension clause, etc. We agree with the interpretation of the learned judge. There's no need for any further evidence. That was a reference, first of all, to Mr. Justice Ango's decision at first instance. So what Mr. Justice Ango had said at paragraph 91, if I can take that first and then explain what the appellant's submissions were, and then with a little more work why the court
is this page 91?
Yes, it's page 91, I apologise. The electronic bundle, page 91.
Yep.
Last three lines, as stated above, Article 1162, clearly spelt out, resolve against the party who's written it, etc. That passage was upheld. We certainly don't disagree with that as a matter of principle, but it's the final paragraph of the judgment over the page on page 92. In light of the above, if there was any ambiguity, the court rules that the contract should be interpreted in favour of the defendants, and that was...
So he's assuming that the defendants wrote the contract.
Whether he's assumed that's the effect of what he said. Yeah. I'm not sure whether it was a misprint or whether it should have said against the defendants in favour of the plaintiffs, or whether he has in fact made a finding of fact on the plea in limine litis, but as my Lord Legate identifies, that's precisely the effect of what he did, and that then was precisely the point that was made before the Court of Civil Appeal by the appellant. Page 164 of the electronic bundle. This is the appellant's skeleton argument. The grounds of appeal before the Court of Civil Appeal are in a few places, but they're recapitulated here closer to the next point. We see on page 164, this is ground of appeal 4 at the top. What the complaint there is stated to be that the learned judge denied the appellant the opportunity to adduce evidence on the merits. In other words, if the plea in limine litis had failed, then there would have been a hearing on the merits at which the authorship of the agreement, which is contested, I should say, between the parties as a matter of fact, would have been determined. And it was wrong of him, in effect, to conclude otherwise on the basis of the plea in limine litis. And that point was developed at pages 172 to 173. Don't propose to go through those in any detail. It's simply to highlight that that is where that submission was made, and that is what the Court of Civil Appeal appears to be referring to in that final passage of its judgment to which I referred. The broader complaint is, of course, that Mr Justice Angle was bound to take the averments of fact in the plaintiff with summons as true. That's common ground before the board, as it has been at all levels of the case, and it's common ground again for these purposes that your lordships must assume that the respondents did draft the agreement. So this was a plain error on the approach of Mr Justice Angle. It's then not directly addressed, that primary error of who authored the agreement isn't addressed by the Court of Civil Appeal, but its approach, which in effect sidesteps that issue, is to say, well, no further evidence should be adduced. This is a plea in limine litis, which was, with respect to the point that was being made by the appellants.
It all depends on ambiguity.
Yes.
Both the judge and the Court of Appeal found there was no ambiguity.
That is true. So that's therefore, for one thing, not a primary plank of Jem's case before the board, but it is still there to the extent that there is any ambiguity. Primary cases, there isn't any, that for the reasons I've given and shall conclude presently, once one follows through the logic of the agreement, Jem succeeds without resort to 1162, but so far as necessary, for the purposes of this plea in limine litis, the ambiguity should be resolved in favour of Jem.
You say that the authorship is contested, is still contested, but I thought that from the Statement of Facts and Issues at page 272, paragraph 8, that the undertaking was drafted by the respondents.
Yes, I'm sorry, I wasn't clear about that. It's contested in the pleadings as a matter of fact.
So, for the appeal.
It's agreed for the purposes of this appeal.
Exactly. For the purposes of this appeal, it is agreed, because that is the approach, coming back to the earlier point that one has to take on this plea.
And to be fair to the Court of Appeal, the wrong point was taken by your predecessor in the Court of Appeal. He was arguing that it should be evidence let in, whereas he should have been arguing that you should assume this point in my favour.
Yes. That said, again, at pages, I won't necessarily go back to them, but on pages 172 to 173, which I read short, the point was
made as well, was it?
Brought in under the penumbra of that ground for, and we maintain that point. I covered quite a lot of what we say is the correct approach earlier, so I'll be scoring out as I go along, hoping not to cover the same ground so far as possible. But as to the correct approach, we come back, first of all, to Article 1161 and construing the agreement as a whole. Standing back before one resumes the detail, what is striking about the agreement is that, as your lordships have seen, the agreement has almost half or perhaps more of it devoted to a panoply of protections for Jem's rights, even where, as we saw, it would otherwise be somewhat improbable that they should still be capable of exercise substantively or indeed procedurally in the case of the waivers to forum non-conveniens arguments. And the respondents say that they have found the only chink in that panoply, in effect, which is that Jem exercised its right to extend the commitment period after 31st of December 2012. If Jem had served the notice on respondents, one or more of whom had ceased to exist, or discovered that the agreement was invalid, still the notice would have been effective, the exercise of the right would have been effective, and the respondents would still be obliged to pay.
I mean, the fundamental point in the whole case is this, isn't it? That did the parties, could they realistically have intended that on a date in 2013, let's say the 31st of July, the respondents are asking themselves, if we sell the shares to someone else today, is there an obligation to pay the commitment fee or not? On your case, there's no answer to that question.
The answer is, as I come back to,
not only do they not know whether they have to, it depends on a future event which may or may not happen, whether the obligation exists or not. And that's simply not a credible intention to attribute to the parties. That's the short of the case.
Well, dealing with that in stages, first, it being the respondents who drafted the undertaking, they have included the waivers on which Jem relies. We say that, again, taking it in stages, the only effect one can give to those is to preserve the right to extend after 2012. there is, and we accept, that period of potential uncertainty during the course of 2013 until and unless the right is exercised. But given the extreme improbability of GEMS not exercising the right at some stage during 2013, if not before, it's...
Well, whether you think that's probable or not depends on how you read the agreement. If you read the agreement as thinking that they've got to have exercised it by the 31st of December 2012, and they haven't, then you're labouring under the impression that you're now free to sell the shares without having to wait another year before you could conclude the transaction.
That's true, but that wouldn't be reading the agreement, including all of the waivers that we rely on. And as I say, the uncertainty is perhaps more theoretical than real on the respondent's point, at least during 2013, if the right to extend hasn't been served before then.
It's a possible middle ground which would accommodate your submissions about the needing to be some purpose in the waiver clauses, that you could extend the period late, provided that in the meantime the sale, which had you already extended it would have triggered the commission entitlement, hasn't taken place.
It is a possible middle ground. You would say it's not.
It doesn't help you, I don't think, on the facts.
No, it doesn't.
But I'm just looking to see. I'm just looking, as it were, around the edges of your reliance on the anti-waiver clause.
I would say it wouldn't be right on the construction of the agreement either, for the reason that it introduces an externality to the contract on which the rights then depend outside the four corners of the machinery, which is otherwise relatively simple.
Well, they do anyway, because if the shares are not sold before December 2013. No commission.
That's true, but that doesn't feed into the machinery of the termination date in the same way, because the termination date is. So that's I think the answer we would give to that. Again, coming back briefly, or just to point again rather than make again the point that on either party's case, this mechanism for the extension being vestigial, then absent a clear requirement to that effect in the terms of the agreement, there is something odd in the suggestion that it is the mere delay, as distinct from the impossibility, the ceasing to exist of a party, that would defeat GEM. And in my submission, there is no such requirement. And in fact, as your lordships have seen at some length, there are express provisions to the contrary, in particular the late notice waiver alone and or in conjunction with the delayed exercise clause. And the board must, if those clauses can be read as producing an effect, give them some effect. Article 1157 is in mandatory terms. On doit is the way the article, or that clause of the article begins. It does depend on whether there are two possible constructions, but in our submission it is possible to give those waivers the construction that we ascribe to them. Indeed, that is their natural meaning, and therefore the court is obliged to give, the board is obliged to give effect to them, as the Court of Appeal was.
Can I just take you back to page 115 and the waiver clause?
Yes.
And that is no failure on the part of GEM to exercise.
Yes.
So the respondent's case is that was a failure to exercise prior to the end of December 2012.
Yes.
Shall operate as a waiver of a right. Okay. Well, as my Lord Hamlin said, the right has lapsed. It's not a waiver at all. It's a lapsing of a right.
Yes.
And so what's the answer to that?
One reads it in conjunction with the late notice waiver, as we've called it. I mean, that's rather an ugly shorthand for it, but on page 100.
The same applies in relation to the...
And this is where answer part one. We would say that preserves the right to serve the notice so that it does exist and is capable of being acted on by the delayed exercise clause, which is on page 115 after December 2012. And on
a literal interpretation of that clause, you wouldn't have to serve any notice at all.
Yes.
And is that, but you don't...
We don't press that because equally it being an iterative exercise, we also stand back and look at the contract as a whole and accept that, as indeed GEM has accepted at both stages below, it does have to communicate the exercise of its right. And for all of the other reasons I've given, looking at the scheme of the contract as a whole, one reads the termination date as 31st December 2013. And these, it's difficult to put these points in a strictly linear order. They all sort of feed back into each other. In fact, coming back to the point Lord Stevens made a moment ago, on the respondents' analysis and indeed the Court of Civil Appeals express observation, it was a failure by GEM to exercise its right on that hypothesis during 2012, which is precisely what that clause on page 115 is apt to capture. The respondents at paragraph 12 of the written case effectively accept that it may well be the case. It's not an outright concession, but one reads it, there may well be no effect that these clauses produce on their approach. It's couched by saying it would apply to delays, if any, provided within an agreement. I take that to mean if GEM exercised its right on the 30th or 31st of December 2012, the waiver would produce some effect. But in my submission, that's really no true effect at all being given to those provisions, and at any rate, doesn't begin to capture the breadth of them. In fact, the respondents do not, in my understanding, contend that GEM would have failed to exercise its right if it had extended the commitment period by the 31st of December 2012. And perhaps in recognition of that, they conclude simply that the laudable request to give effect to every clause of an agreement must stop at the frontier of logic and common sense, is what they say. But that is contrary to what I've mentioned of the mandatory terms of Article 1157. One must, if possible, give effect to the provisions on which GEM relies. And there is no, on the contrary, no sensible meaning to be given to delay except beyond 31st December 2012, and a fortiori, no sensible meaning to be given to failure except the failure to exercise within the course of 2012. That brings me back to the fundamental error of the Court of Civil Appeal in treating the duration of the commitment period as necessarily the same as that of the agreement, and certainly in doing so, in my respectful submission, without any supporting analysis. They are not the same. Again, not to reiterate, but to point back to the forum non-conveniens and other litigation-focused waivers, those must have subsisted beyond the duration of the commitment period. And GEM does not have to put it nearly so bluntly as the respondents do, and as the Court of Civil Appeal did, in terms of when the shutters come down on all of the provisions of the agreement. Rather, GEM's case, as I've explained, is that it was entitled to exercise its right to extend up to and including the termination date of 31st of December 2013.
Could I just ask you a question about the delay in exercising clause on page 115?
Yes.
I think I'm right in saying that the shareholders are treated within this agreement as separate persons, as indeed they are. So I just wonder whether sensible effect can be given to the no delay in exercising clause and so on, when one has regard to the fact that notices may be given in time to particular shareholders, but then there may be some delay in giving relevant notices to others. But if you're within the commitment period, the fact that you delayed in giving notice to some shall not prevent you from exercising whatever rights you have in relation to those persons. So in other words, it's addressing the fact that you might have acted in relation to some of the parties to the undertaking, not in relation to others, and effectively is saying, well, no inference or waiver can be derived from that if it happens.
Yes, I'd venture three answers to that. The first is that is not it is envisaged that an extension notice singular will be served on all of the shareholders who are treated compendiously throughout the agreement. So what we would start from the position that that wouldn't be the most natural reading of that clause, that the shareholders are treated as a block. There's one notice to be served on them, and it's not necessary, it's not immediately clear that that's what it would be envisaging, as opposed to the more outright failure to serve a notice at all, or delay in doing so during the commitment period.
But does the agreement specify how you serve on them as a block?
No, it doesn't. And I should also say, secondly, that we, although we've said, putting it perhaps strongly, that these are really the only, it's certainly the only primary right that GEM can exercise under the contract. I return to that point. We don't put it quite as strongly when it comes to the scope of the waivers and the delayed exercise clause in particular. It's difficult to see in our submission what else they could refer to, but we don't have to succeed on the fact that they could only refer to the exercise of the right to extend. It's certainly sufficient for the purposes of our argument if that is if the exercise of the right to extend is at least an important element of what what would be caught by them, then they would still be deprived of effect on the respondent's case if they didn't. And secondly, or rather thirdly, sorry, it appears, it's not spelled out in the agreement, but the liability must, I suppose, be joint and several, in the sense that if any of the respondents ceases to exist, then the right to the commitment consideration is unaffected, and therefore failure to serve on any particular respondent also for that reason, an underlying reason inherent in the contract, wouldn't necessarily make that a necessary reading of the delayed exercise clause.
Yes, I was just wondering about the phraseology in the clause on page 115.
Yes.
Referring to any single or partial exercise of any right.
Yes. It may well be that that may well be what those particular words refer to. They're not the words on which GEM relies, and will, as your lordships have seen, each of the waivers is framed quite compendiously and with various limbs pointing in different directions to capture all sorts of different mischiefs that might have gotten in the way of GEM's right to payment.
Yes, thank you.
There could be difficulties about service on the notice under the previous clause. All
Yes.
notices are to be delivered to the relevant party at its address. So you've got many addresses for these shareholders, and so it might cover a situation where there has been a failure to serve out the address, but all the same, the individuals receive the notice.
That's true, and it may well be, let's take a step back, when one's dealing with what are effectively so many boilerplate clauses that they may well overlap. That would naturally perhaps fall within the late notice waiver on page 114, and I would just make the point, to the extent it may matter in due course, GEM wouldn't necessarily say that although the exercise of the right requires service of a notice as it's accepted, the service of the notice is still analytically distinct from the exercise of the right, if that makes sense, and that's why perhaps it's more the page 114 clause than the page 115 clause, using an even less elegant shorthand than we've used hitherto.
So, sorry, what do you say is the meaning of what you call the delayed exercise clause, but on one reading of it, it abolishes the requirement to serve a notice at all, but you don't say it has that effect?
No, coming back to the answer I gave earlier, it's we adopt an approach that gives effect, indeed pretty significant effect, and the necessary effect to these clauses, but does, again, step back and accept that the right can be exercised silently. There must actually be some communication of the right. And so even from a self-interested perspective, GEM is obliged to send the notice if it is, or rather it's required to send the notice if it's actually exercising its right. So we don't say it goes just as far as that. It doesn't have to, and not even for the purposes of giving effect to those waivers. GEM's primary case, as I see, is that all of that results from perhaps not a quick reading of the agreement as a whole, but a thorough reading of the agreement as a whole, and giving effect to all of it is necessary. That in the end there isn't an ambiguity about it once one follows down all of those loose ends. But I conclude by saying alternatively, to the extent any ambiguity does arise, that's where we rely on Article 1162. Was there anything else? Unless I can assist your lordships further, those are my submissions.
Well, thank you very much, Mr. Donnelly. The board will take 5 minutes or so to confer and see where we've got to. We'll be back in 5 minutes. Well, we won't need to trouble you, Mr. Duval. We're most grateful to Council for their submissions, written in one case, written and oral in the other, and the board will take time to consider its judgment. Thank you very much indeed.